Good afternoon, ladies and gentlemen. My name is Carla. I'm the operator assisting on today's conference. I'd like to welcome everyone to the Why You Need a Durable Power of Attorney conference. Your lines have all been muted to prevent any background noise. There will be question and answer sessions held throughout today's conference. At any time, you may submit your question to the queue by pressing star and the number 1 on your telephone keypad. To remove the question, you may simply press the pound key. I'd now like to turn the conference over to Ms. Kate Anastasia, the Program Director with Alzheimer's Association of Long Island. Please go ahead.
Thanks so much, Carla. Welcome to the Alzheimer's Association Long Island Chapter's information session, Why You Need a Durable Power of Attorney. The program is designed to help persons with dementia, their care partners, and family members understand the importance of planning and advance directives. We are very fortunate to have Irene Villaci with us today to present this information. Irene has over 20 years of legal experience in elder law, estate planning, Medicaid planning, and special needs planning. She's the Vice President of the Women's Bar Association of the State of New York. She serves on the chapter's legal committee, has a passion for pro bono work, and is a true friend to the Alzheimer's community. I'd like to welcome Irene Villaci.
Oh, thank you, Kate. Thank you, Carla. Good afternoon. I'm glad that so many people have joined us on a cold winter day. I guess having this in such a bad time of the season is a good way to have a captive audience, but I do hope wherever you are, you're warm and comfortable. So my topic today is to speak to you about why you need a durable power of attorney in New York, why that's so important, and why it should be carefully drafted. The power of attorney, for many of you who might be confused by what a power of attorney does, is specifically in New York geared towards financial transactions. Everyone talks about advance directives and powers of attorney, and a lot of times in other states you might hear of medical power of attorneys and healthcare powers of attorney. But you should know that for New York, as is our topic today, the durable power of attorney is solely for financial purposes. In New York, we do not use a power of attorney for health purposes. And the two key things about it being a durable power of attorney that you should keep in mind throughout our discussion today are as follows. One is that having a power of attorney is important so that at any point from the time that you sign the power of attorney, at any point after, should you become incapacitated, whether that's a physical incapacity, whether it's a mental incapacity, or anything that prevents you from managing your assets. The problem with that is that a power is to prevent a guardianship. It is to prevent your assets from being frozen or not used while your bills need to be paid, while you might need to be cared for. And that's why a power of attorney is so important. Why is it durable? Under New York law, if a power of attorney does not have the durability clause, then what happens is, if I were to sign a power of attorney today and it does not have the durability clause in it, what happens is that if I suddenly became ill where I was physically incapacitated, that I could no longer sign my name, or mentally incapacitated, perhaps having a brain injury or Alzheimer's disease, and I couldn't manage my finances, if there is not a durability clause in my power of attorney, my power of attorney cannot be used once I become incapacitated, which sounds odd, and it is odd, and it totally defeats the purpose. So any power of attorney in New York, when you're planning for incapacity, should be durable. And the durable clause is simple, and it is in any well-drafted power of attorney. And it simply states that this power of attorney will remain in full force and effect, will still have legal effect to it in the event of my capacity, whether I'm under a physical or mental capacity. As simple as that might sound, unless that durability clause is in there, my power of attorney will not be durable. So those are the two basic thoughts about a power of attorney that I want you to keep in mind going forward. Having a power of attorney carefully drafted today is so important that we cannot stress it enough. I know that a lot of people are saying, well, as an attorney, maybe the attorneys are just looking to make money, and I just download it somewhere on one of these, do-it-yourself legal packages, or can I just go to one of the big computer stores or stationery stores that will have the forms. That might have gone well 20, 30 years ago, but what we have found in elder law planning is that unless it's drafted carefully, considering all the possibilities that could happen to you, we might end up in court for a guardianship proceeding if your power of attorney is not carefully drafted. For instance, I'll give you a very good example that happens so often. What a power of attorney does by having you sign it is that you have appointed the agent that you want to handle any of your financial management if you're unable to. If you don't have a power of attorney that is well drafted and covers as much of the anticipated situations as possible, you could end up being the subject of a guardianship proceeding down the road. And this happens a lot. I dread to say it, but there have just been too many cases, too many files in my file cabinet over the last several years where I had to bring on a guardianship proceeding because persons were in need of having their financial assets managed, and they either had not done a power of attorney, or their power of that might have been done either by themselves or by another attorney was done years ago and now did not cover all the consequences. And here's a good example. Where I have someone that has done a durable power of attorney, but it wasn't quite what it should have been. There are powers of attorney out there that still limit gift giving. The old powers of attorney used to limit gift giving to $10,000. And currently, under the new power of attorney, unless it's properly drafted with what we call the gifts rider, gift giving is limited to $500. Now, in some circumstances, and some of you might be saying to me, well, isn't that a good thing if I stop someone from making gifts to themselves? Well, yes and no. First of all, you appoint someone that you trust is going to handle things only for you in your best interest. But second of all, where I have someone who now might need long-term planning. A good example, of course, for our Alzheimer's Association today would be a client that has advanced dementia and they need care. Perhaps they need Medicaid in the home. Perhaps they are in a nursing home. Perhaps they need care even if it is privately paid. But the bottom line is they have a power of attorney and no one is able to access and transfer monies out of their name if they can plan to qualify them for Medicaid, because the power of attorney is not sufficient when it comes to gift giving and moving assets. A good example might be where we have spouses. So if I have a husband who is capable and he and his wife are married 50 years and the wife suddenly has advanced dementia and the power of attorney they did 10, 20 years ago is not sufficient, and now she needs to have assets taken out of her name and transferred to her husband so that she can go on the Medicaid program where the state pays for your care. What happens is husband goes to the bank using the old power of attorney, and he gets stopped because the bank says this power of attorney doesn't allow you to make gifts to yourself, or this power of attorney only allows you to make gifts to a certain point, to a certain dollar amount. So we're sorry, Mr. Smith, but you can't take the money out of your wife's name. It happens very often with investment accounts. So what happens as a result is that Mr. Smith cannot move the monies out of his wife's name so that she could get on Medicaid. And what he is risking is his assets that they've worked for all their lives from being subject to spending down for her care. Another good example is where a couple like Mr. and Mrs. Smith own a house. So if Mr. Smith needs to transfer the house from him and Mrs. Smith to himself so that Mrs. Smith, again, qualify for Medicaid, but they want to avoid Medicaid putting a lien on their house, Mr. Smith thinks that he can go ahead and do so by just using the power of attorney that they signed 10 years ago. But as it turns out, when Mr. Smith goes to do it, he brings it to a lawyer who shows it to their title company. They find out that the power of attorney is not sufficient because the provisions in the power of attorney do not allow it. And as a result, Mr. Smith has to petition the court to become Mrs. Smith's guardian. And a guardianship proceeding can be very lengthy. It can cost a lot of money between the attorney's fees and court reporter fees, and then it really would tie up Mr. and Mrs. Smith to accounting to the court every year, and that's very invasive. It's paperwork, it's attorney's fees, and it's also for the lifetime of Mrs. Smith that she has remaining, it's where Mr. Smith has to answer to the court about the personal life that he's sharing with his wife, and to many clients that's invasive. What a good power of attorney that's carefully drafted will do is it will allow the person you appoint, whether it's your spouse or your most trusted family member or friend, to transfer assets if they need to divest you, to continue your estate plan. Some clients make trusts and then they become ill. If the trust needs amending and a good power of attorney allows for the power of attorney to amend the trust, then your estate plan can be continued in the method that you tried to do it before you became incapacitated. So there's much to do as far as what a power of attorney can be done. I think at this point, Carla, we may want to open it for questions because there's another piece of it that I want to offer to our listeners, but I just want to see if they have questions first.
All right, ladies and gentlemen, again, if you press star and the number 1 on your telephone keypad, that will submit your question to the queue. We'll give it one moment to see if any come through. And at this time, I see no questions.
Okay, that's fine. Then we'll move on. So that is just some of the provisions of the power of attorney where it can be helpful. But one reason, the main reason why we look for a client to have a well-drafted power of attorney is when we do Medicaid planning for nursing home, planning for incapacity, one can just anticipate so much. That if we were to anticipate all of it, we would need a crystal ball. That's what I tell my clients. I have, one thing we have no control of is what's going to happen as far as our health. We can do all the right health planning and we can do all the legal planning, and we never know where we're going to be 3 years from now or 5 years from now. So when a client comes into the office, we try to anticipate it, but we can anticipate it a lot by our experiences. So what I've seen over the course of 25 years as an attorney, what I've seen happen based on the current status of the law, and also knowing a little bit about the diseases and what the healthcare professionals tell us, we can anticipate. So when we do a carefully drafted power of attorney, we know from past case law, past situations with clients having experienced, no-win situations, that our powers of attorney have to anticipate as much. And if clients try to draft it themselves, they're really just getting today from the state statute form a basic form that requires a lot of initialing, a lot of thought, a lot of filling in and anticipating, and that's not something that someone should try on their own. It's something that you really do need to sit down with an elder law attorney who handles powers of attorney in order to try and anticipate. We generally, have to anticipate how to protect your home, how to protect your banks. If you've already done trusts, as I've said, anticipating that as well. The second thing, as far as the power of attorney, goes back to who you are going to appoint and who you would give the self-gifting provisions, and that's important too. So under the new power of attorney, which is, we call it new, it's almost 5 years old. Under the new power of attorney form, the person you appoint now, who is now called your agent, has to actually accept it. And that means that on a page after you sign your power of attorney, the agent has to also sign. Those signatures have to be notarized as well. And so the agent is accepting their duty. Their duty is to carry out your financial management for you in the event you cannot carry it out yourself. Their duty is to act in your best interests and to use your monies only for you, for your benefit, unless you state otherwise. So normally, you might appoint your spouse, and then you might appoint successor agents. Successor agents could be your children. You are allowed to appoint co-agents under New York law. With co-agents, you have a choice of whether they're going to act separately or together. Separately is usually more practical, where we have co-agents who get along well, and you know that they will abide by your wishes well, but perhaps they're the kids in the family that wear many hats. So if you have that one child who really knows most about your banking, but also knows about your medical issues, and perhaps that if you're ill, that child is in the hospital waiting to speak to your doctor, but the tax bill has to be paid, it might be a good idea to have a co-agent who is the other person who's always been the second help. And if that person is assigned as a co-agent and they can act separately, then that co-agent could go to the bank, and that co-agent can pay the real estate taxes while the other kid is standing in the hallway of the hospital waiting to speak to the doctor. The other choice is to have them act together, which means jointly, which pretty much means that the co-agents cannot sign papers, do banking, write checks, unless they both are present signing the signature cards at the same time. That might be a little bit cumbersome in families. In either case, they could both check over each other and make sure everyone's doing everything accurately and according to your wishes. But your agents all have to accept their responsibility in writing on the power of attorney now under New York law. Talking about the self-gifting provision. The self-gifting provision is where, in New York, if you are an agent under a power of attorney, you are not allowed to make gifts to yourself. So if I have a power of attorney and I designate my children as my agents, unless my power of attorney specifically says so, my children cannot make gifts to themselves. Now, the first instinct as parents is, well, that's a good thing. But if we're thinking about our planning and we're thinking that we trust our kids and the ones we're appointed are the ones we know who have our best interests at heart, we also have to realize that it's in all likelihood that the kids that are named in our power of attorney as our agents are probably also the beneficiaries of our wills and our estate plans. So if my children are my beneficiaries and my children are also my agents, and I do not execute the piece that says they can give to themselves, well, then I have another logistical problem, because who else would I want them to give the money to if I needed to do Medicaid or other estate planning? So the self-gifting provision is important. Again, these are all provisions that you would not want to add in on a do-it-yourself situation unless you reviewed them legally and had an attorney go over your family situation and your asset situation and your future planning for your long-term care. So that's very important. Carla, do we want to take questions at this point?
Ladies and gentlemen, again, star and the number 1 on your telephone keypad will submit your question to the queue. And I have nothing coming through at this time.
Okay. So let's focus as far as other powers of attorney. What's also something that is that requires choice, and again, why we say don't try to do this by yourself, is that the power of attorney law under New York gives you the choice as to whether the new power of attorney that you're signing revokes prior powers of attorney. Now that, you might think, comes out of course, if any of you have signed wills, because in most wills that are drafted, the opening paragraph always says, I hereby revoke all prior wills and codicils. And because it was in our will language, many people still presume that that must just be the case with all legal documents. But that's not the case. That has just always, that's something that we have to expressly state in our wills. So for a long time, many people still believe that, well, if I sign this power of attorney, all my other powers of attorney are revoked. So people were doing that, and, you could end up with someone having 4 or 5 powers of attorney over their lifetime, and maybe they're all to different people. Maybe there's one to your business partner. Maybe there's one to your first husband. Maybe there's one to your second husband. And then maybe there's one to a child or a relative that there's been some sort of a falling out. Well, all of those persons have power of attorney. Signing a new power of attorney does not necessarily revoke all those past ones. So what would happen is we'd have 4 or 5 people out there with valid powers of attorney, and that could be a mess when it came to planning for an incapacitated person. So now with the power of attorney, another reason why it's important, it's a careful consideration, is to find out You still have powers of attorney out there, and are these powers of attorney that we would want to keep? For instance, if it's people that you don't want to have any access to your financial information, then your new power of attorney absolutely should say it revokes the prior powers. On the other hand, if really what your new power of attorney is doing is expanding upon what could be done for you in the case that you become incapacitated, but maybe you have an old short form power of attorney on file with the bank, and you're really not doing anything but changing the names and writing a more elaborate power of attorney that will hopefully cover all situations, you may not want to revoke the old power of attorney. You just want them to coexist. And in that case, we would not put in a clause that says you're revoking it. So the new power of attorney has a spot where you could actually decide whether you're going to revoke it or not revoke it. But again, these are all careful situations, and in living with a world where check this box and check this box, it's not a matter of everyone fitting into the same mold. It really has to go by what is your financial situation, what is your health situation, what is your family situation, and what are your beliefs as far as how you would want your estate plan to be carried out in the event that you're incapacitated. And the power of attorney has to be curtailed to all of that. It has to allow for as many scenarios that can be played out, which is why every power of attorney should be customized to the person and not just something that you find on a form. I could tell you that I have too many cases on my desk now where mom or dad are very ill, and we don't know if they can sign new powers of attorney, and the kids were doing their best and they just ran out and got a form from a friend, and they filled out a power of attorney that was essentially empty. It had all the state language, but it was missing all the provisions that you could fill in and use. And maybe now we're in a dilemma that we can't transfer a house or we can't sell a house because that power of attorney didn't have enough provisions. It's always important to remember that New York State law, when it comes to powers of attorney, pretty much the given is that if it's not written in the New York power of attorney, you cannot do it. So, that's why powers of attorney over the last 4 or 5 years went from a form that was maybe 3 or 4 pages long to a form that's about 15 pages or so when it's written correctly and anticipates all of the client's needs. So I put that out also to you. The clients ask about, how it should be executed. And now under New York law, it has to be signed and notarized by you. It has to be signed and notarized by your agent. And assuming you are also signing that gifts rider, the gifts rider not only gets notarized, it also gets witnessed by 2 persons. And as a warning that I put out there to all clients, if you really want to take the risk in doing it yourself, which you should not, you should not have the notary or the witnesses be anyone related to you or related to the persons you're appointing, because again, that could be looked upon as something that's self-serving. And the whole idea of the power of attorney is to help you in the future should you need assistance and you can't speak for yourself. So having everything properly executed, above board, and planned out is really the best way to make sure that in the future, when needed, your power of attorney will be there to help you and not to restrict what you and your loved ones can do to care for you. And I think really at this point there's so much of the basics that I covered. I really want to see if there are any questions.
We'll go ahead and wait a moment. Again, folks, star and the number 1 on your telephone keypad. I will be introducing you by first and last name. My apologies in advance if I mispronounce anyone's name. Your first question comes from Nina Nichols. Please go ahead.
Is Nina
Ms. Nichols,
there?
if your line is muted, go ahead and unmute it at this time. Ms. Nichols, if you've got a muted line, unmute it so that we can hear your question, please.
Good afternoon.
Hello.
There we are.
Hi. Sorry about that. The question I have is that my mother was living in Florida, and she has a POA signed with my brother. And she has since relocated here to New York and is living with me. And she has been diagnosed with moderate stage dementia. I want to know, if she signs a POA up here, does that revoke the one that's in Florida?
Again, it's going to be that if the power of attorney that's signed in New York, if it states that it revokes all prior powers of attorney, it can be assumed that the Florida power of attorney and any other powers of attorney out there are revoked. So that would be a very serious thing to consider as to whether an out-of-state POA should be revoked, especially if the parent has assets down there, bank account down there, and there's really one family member that's nearby. That's something we would consider. Say, do we really want to revoke an out-of-state POA? Do we need that out-of-state POA?
Well, all her assets are now appear in New York. She doesn't own a home or anything like that. And the bank accounts are, with a bank that has branch here as well as in Florida.
Again, when she goes to sign the New York power of attorney, then that would all be considered as to whether there should be a revocation clause in the New York power of attorney.
Okay. All right. Thank you.
Sure.
And we have no other questions at this time.
Okay. One thing I just also want to add about the revocation clause in the power of attorney that I thought about when Nina was speaking. It's not unusual, and that when we go to banks, that they ask us to sign their own form, which is the bank power of attorney. It's not unusual. And so that's an important question to ask when we're drafting the current power of attorney as to whether or not there are bank powers of attorney out there. Because if the client just went last week and put their kids on the bank power of attorney, as would I have them revoke it? Not necessarily. What I usually would do is make sure that the client has the new expanded power of attorney as well as the bank's form on file with the bank, because the banking world is used to having their own forms on file as well as yours. I think that we have pretty much covered the whole topic of the powers of attorney. As far as who should have powers of attorney, everyone should. If you're over the age of 18, there is no reason for you not to have a power of attorney. Certainly because this is part of our Long Island Alzheimer's Association's public services, and because Alzheimer's is something that not only have I tackled in my own family, but tackle every day with our clients and what they're facing and struggling with. A power of attorney is for everybody. So if you're over 18, you should have one. The minute you're over 18 and have a bank account, you should have a power of attorney. I have clients that, if their kids are going to college and the kid has to open a bank account wherever they might be in another state or upstate New York, where it's at a bank that's a local bank and the kid has money there and the parent wants to have access to it, maybe to watch how the kid's spending the money, but also have access in case the child gets sick so that the parent can handle some financial transactions. Well, it's just as important for that 18-year-old as it is for the 88-year-old to have a power of attorney. And unfortunately, in my career, seeing clients with mental incapacities of all types, by horrible accidents, by diseases, and diseases such as Alzheimer's, you are never too young to plan ahead. And a good, solid, durable power of attorney should be part of everyone's estate plan, whether you have a $3 million estate or whether you have a $30,000 estate. Everyone should have a solid power of attorney. So I think we probably could take any concluding questions on this, Carla.
All right, folks, let's have our last questions. It's submitted with star and the number 1 on the telephone keypad, and we'll give it a moment to see what comes through. At this time, there are no questions.
Okay. Kate, I think at this point, do you have anything else that you want to add? I don't know. Did we lose Kate?
No, she needs to unmute her line, please. Oh, yes, indeed, we may have lost her.
Okay.
And I don't see her dialing back in. Oh, wait, yes, I do.
Okay.
One moment.
Kate?
Yes, I'm so sorry. I went to unmute my line and hung up.
Okay. I think it's okay. We lost you there. We're glad you're back. I think that with the question that we had and my remarks, I think I just wanted to check to see if you had anything to add for our callers.
No, Irene, thank you so much. I think that was a great overview of, the advanced directive piece and the durable power of attorney. Just want to remind folks, too, that they can always check our website to see about any additional legal or financial planning programs that we offer. And, of course, check our website for some of our online programs that focus on the legal and financial planning piece as well. But thank you so much for a great presentation.
Thank you very much, and it was always a pleasure to help the Alzheimer's Association and those who seek its support.
And Carla, thank you too.
Oh, you're welcome, ladies. Ladies and gentlemen, that concludes today's conference. You may now disconnect. Speakers, stay on your line for one moment, please.
Thank you.